Okay, it's my pleasure to call to order the 31st public meeting of the Massachusetts Gaming Commission, probably a record, on October 16th, 2012. First order of business is the approval of minutes, but I think we haven't had a chance to review them.
Right.
I haven't.
Did it in this morning, and
Right.
they're in draft. There's a couple of things that need to be filled in, but
So
we'll do it next week.
put those off for next week. Okay, we get to topic number 3, project work plan, and first up is our consultant team, some of them at least.
Yes.
And would you mind giving me a couple pieces of paper again? I forgot again to bring my pad. I'm getting used to using yours.
Minutes is sitting there, but I don't see it.
Morning.
How are you?
Well, fine, thank you. Good afternoon, that's true.
Why don't you introduce your team to the masses of public out there?
Yes, this is the all-star team. Steve Ingus on the left from Spectrum, Bob Carroll, Michael and Carol, and I'm Guy Michael.
Okay.
Thank you. We have a report to give to the Commission with regard to the progress that the consultants have made over the past week. A lot of the time, or bulk of the time, was spent supplementing and refining the strategic plan. And we have arrived at a second draft version of that plan, which was delivered yesterday.
Right.
And the areas, the key areas that we focused on in terms of this new draft were in response to some of the questions that we had received from the commissioners about the first draft. We have changed provisions and some of the recommendations to reflect, for example, the recent Department of Interior disapproval of the Mashpee Compact and the impact that that might have on the Commission's timeline and development going forward. We've adjusted and clarified some of the other aspects of the timeline, tables of organization and the associated budget line items to better reflect some of the interests of the commissioners as they express them. We expanded the detail and prioritized the MOUs, the Memorandum of Understanding, and what will be necessary and what we might be able to do later, and what we have to prioritize and do more immediately. We enhanced the compulsive gambling program recommendations. You'll find that in there. And we also included and evaluated some of the potential legislative recommendations which had been discussed previously regarding, for example, additional commission funding and other temporary gaming facilities and other more technical aspects of the legislation that could use possibly some tweaking. In addition to the strategic plan, we researched and conferred about the best practices on the scope of licensing and qualifier identification processes, which we anticipate will be moving forward quite soon, and want to use that process to ensure consistency in the evaluation of each of the applications so that there is a very transparent and uniform way in which we identify who has to qualify and who does not. We are also researching and identifying and discussing various policy issues that the Commission will need to address in order for us to move forward with the regulatory drafting process for Phase 2. There are a number of issues that will arise in the context of the Phase 2 regulations that the Commission needs to give us direction on, and we have identified those areas and look forward to speaking to you about them.
And this was also, excuse me, Bob, these were also about issues that the municipalities and or the developers might need a heads up on.
Absolutely.
Where we're going to be coming down on something that it's better for them not to wait until we actually write the regs.
Exactly.
Yeah, okay.
Exactly. That some policy directives could be issued
Right.
in advance of the regulations.
Right.
And we've, begun the drafting and evaluation process on the Phase 2 regulations themselves. We've assisted the Commission in terms of identifying and performing some due diligence on potential candidates for positions with the Commission staff. So, as I said, that's been our week. Otherwise, we weren't doing
Just
anything.
sitting around.
So, and we look forward to, yes, tomorrow's meetings with you to go over a lot of these areas and be able to move forward even further.
Right.
We're open for any questions that you have.
You had raised some issues yesterday that you were going to bring about the sequencing of the, I mean, this goes right down into A, B, and C, I think, including the RFA timeline that was in that, I think, section 8 or 9. Do you want to
Yes,
raise
section 8.
those? Because we haven't confirmed the process of the qualifier hearings yet, and we have some issues you raised, so do you want to?
Yeah, Section 8 of the statute speaks about requesting applications first for the slots parlor license, the Category 2. And as we prepare ourselves for issuing the document, maybe originally contemplated tomorrow, or contemplated tomorrow, we should consider issuing that application, that request for application for the slots parlor first to comply with the statute, and then perhaps a couple of days later, because we're ready, for the Category 2 license as well. I contemplated whether the statute may have intended letting out the license, but I believe that Section 8 is very clear relative to the request, which is really upcoming.
Right, that it's not the granting of the license,
Granting of the license.
it's the release of the RFP.
Right.
Or the what we're calling the RFA, right?
And there was also some, I had considered whether, given our bifurcated approach, we could, and given the fact that everybody will have to go through the RFA Phase 1 process anyway, whether these compliance with the statute could be ascertained to be RFA Phase 2 request for proposals. But I just wanted to bring it up. It's essentially now the time to consider if we needed to make the distinction to have that be on RFA Phase 1, we ought to consider it today.
We ought to consider it today. It seems to me that one can interpret the statute as saying a day, it does say we should issue the Phase 1, issue the RFA for the slots parlor first. And literal compliance with that, it seems to me, could be satisfied by issuing it a day ahead of time. And I don't think that's what the legislature intended. And it seems to me that if we issue the RFA 1, now that we've bifurcated the process, because the statute doesn't explicitly anticipate that process either, although it's perfectly consistent with it, that if we issue the substantive RFA 2 for the slots parlor first, perhaps even trying to deal with the RFA 1s for the slots parlor applicants first, if we can work the rest of the schedule, so we could substantively consider those licenses ahead of the others, we'd be fully complying with the statutory command. And this would allow us to get everything underway quickly and uniformly. So I think we could, perfectly consistent with the statute and the spirit of the statute and the legislative intent so far as it can be divined, we're perfectly compliant if we issue the RFA for everybody tomorrow, RFA 1 on schedule, and then think about the substantive RFA 2 piece going first to the commission, to the slots parlors in substance as well as in temporal sequence.
I think that would be within the law for sure, but I'm not sure that doesn't cause us potentially a bigger problem. If it turns out that a casino license applicant is ready to go with RFA 2 before the RFA 1s come in, we would be sitting there holding. I think my guess is that the legislature was trying to do a few things in the bill to get us to move as quickly as possible, and to get money rolling as quickly as possible, and to get economic development rolling as quickly as possible. They sort of assumed that the slots parlor process, because it was quicker, et cetera, but they certainly did not mean it to slow down the casino process, you know. So what I was thinking was that we issue the slots RFA, make it available to slots applicants tomorrow, and we wait, say, till Monday, just to be sort of spiritually in compliance with the letter of the law, though I don't think this is really what the law intended to do, to make us wait on the casinos. But that would give us a few days, and then this issue is behind us, and we can then take the RFA ones as they come in without still having to be worried about complying with this legislative mandate.
Well, I think that if one is looking and trying to divine what the legislature intended, it seems to me perfectly rational to conclude that they thought that a slots parlor could be erected, created, and up and running much more quickly than a Category 1 casino could be, and therefore that the revenues to the Commonwealth and the job creation that they would bring could be done more quickly. And from that standpoint, it seems to me that while we would comply with the letter of the law, and we certainly can do as you suggested, while we'd comply with the letter of the law if we waited 3 days, that's not really what this is all about, and that we still would be observing the underlying intent, so far as it can be divined, of the legislation by trying to expedite the issuance of the substantive RFA 2 for the slots parlor.
But that would put us in the position, if it turned out, that, as we know the lay of the land now, the slots parlors are going to be new folks who have not gone through the background check. Everybody's got to go through the exact same background check. And it's perfectly possible that because this is a new experience for the people in the slots license, that there'll be fits and starts and issues about qualifiers and debates about the data, and it'll take longer to get the data. So we don't have any way of knowing what would come in first, but if we did what you're suggesting, if the RFA 1, if the casino background checks were concluded first, we would have put ourselves in the position of having to wait until the slots license background checks was completed, which I think would be antithetical to what the legislature was wanting. You know? So I think, but I'm just guessing here too, but my guess is the legislature was trying to do something to move the process along. As it turns out, because the background check is exactly the same, RFA 1 is exactly the same for both kinds of licenses, there's no way by issuing it first that it's going to have a material impact. So I think we just have to get ourselves past a technical non-compliance if the sequencing, if later on, if RFA 1s come in a sequence that cause casinos to go first, we could take care of that by taking care of the mandate to go first at this stage of the game, where it's no skin off anybody's nose if we miss 3 days.
I actually agree with Commissioner McHugh that we really should try to adhere to the legislative intent, and I actually believe that everyone's been doing their homework in the Commonwealth, and they know what to expect. They've been reaching out to folks who have gone through this background process before, so they'll be prepared to complete those forms in a very timely manner, and then it's up to us where we want to focus our investigative resources. And I think that we could focus with the slots license first with our investigative resources, and of course, if something happens where we have to make a different decision, we could at that time make a different decision. But I don't anticipate someone not being prepared for the background investigation phase. It just seems to me that everybody's been partnering with someone who's been through it before, or consulting with someone who is very experienced in this area. So I just don't see that delay just because it's a slots license.
But couldn't we, for the intention of the legislature, the legislation, which was to issue the slots parlor license first. Couldn't we take it as this applies to both phases, just to be safe? Perhaps one with a technical coverage by a difference of a few days, and the second phase by a substantive coverage, because we'll find out when we get there, and we can issue that license first.
I think that's perfectly, well, the first part of it, there's no reason we can't, except that we haven't said this before today. There's no reason that we can't issue the RFA one for the slots parlor tomorrow on schedule, and issue the other one Monday, Friday, whenever, and thus technically comply with the literal language of the statute. I just raised the other point because I think we would be misapprehending the legislature's intent if we thought that that was enough, and having complied with that literal technical requirement, we were free to do thereafter anything we chose. But we need not decide that today, and in fact, how we structure the rest of this is part of tomorrow's discussions and the strategic plan discussions, and is something that we'll be talking about intensely over the next few weeks. So if we want to issue the two RFAs sequentially, there's no reason not to do that, and then return to this in our usual thoughtful, carefully planned out fashion as we move forward.
So that go ahead and do the slots RFA 2-3 days earlier now. So we've got, if we want to decide that we've put that issue behind us, we can. And then later on, we can talk further about whether we want to wait on the casino slots the casino background checks for the slots background checks.
Right. It's an option-preserving step. I don't think we should wait very long before we take the next decision step, but certainly we've preserved our options by doing it.
You guys have...
We agree. I mean, that seems to be in the way, there is a distinction.
We agree with what?
With what Commissioner McHugh just said, in terms of a sequential, or as you suggested originally, sequential issuance. The distinction, obviously, in the issuance and the decision-making process, will be maintained in the future. The Commission already built into the regulations the efficiency of having all of the backgrounds commence at the earliest possible time. And then, as you've indicated, they are the same, okay? How you allocate your resources once these packages are out there and being requested and come back in will be something we'll be discussing pretty aggressively in the next 48 hours, say. And then as the compliance of the various applicants, the amount of resources they put into getting this done as quickly as possible will, to a certain degree, allow the parallel tracks of the, the 1 and 2s to proceed, and then decisions can be made down the road. But for today's purposes, the issuance is obviously the key, and if you do it, as Commissioner McHugh said, you could do it at the same time or a couple days in between to have an absolute technical compliance.
Right.
We don't think it would make a big difference, but there is, the idea to get that out, I think, is important to stay on schedule.
Right. I'm fine with that. I'm fine with, if we do it, let's say, Wednesday and Friday, then we accomplish both objectives, which is have a technical compliance under our belts if we need it, and leave open the option of how we allocate resources and move forward. So I'm fine with that. I think we probably ought to have this be a motion. Commissioner, do you want?
Surely. I move that the Commission issue an RFA 1 for the slots parlor on Wednesday, October 15, 2012, and that the Commission thereafter issue a RFA 1 for the Class 1 casinos on Friday, October 17, 2012.
Second that motion.
Any further discussion?
Excuse me, it's Friday, it's technically, it will be the 19th.
What did I say?
You said the 17th.
17th, it should be 17 and 19.
17 and 19. As so
Okay.
amended, I continue the motion.
Thank you.
Calendar in my head.
Fortunately, we got high-priced consultants.
Right.
Any other discussion? All in favor?
Aye.
Opposed?
Opposed.
Opposed? Oh, did you want to speak to the issue?
No, it's,
Sorry.
no, I apologize for not probably voicing my opinion at the appropriate point. I just, just opposed.
We also need to talk about, and we need to do it we can't put things off for another, this is our public meeting where we need to talk about the things that need to be talked about in public. We have not, I don't believe, where's Kristen? Yeah, we talked about this yesterday, but I don't think we came up with the formal details. We've talked about having a group meeting for everybody who wants to take an RFA1, was for some kind of common presentation to everybody about the process, where people can ask questions which are generic, and everybody who's interested will hear all the same thing, where there would be consultants there and at least some representation of the commission. And then start the scheduling of the individual qualifier conversations for those applicants who feel the need to have those.
That's correct.
And I've heard from various people that they kind of like that idea as a process. Have we locked that in yet?
As far as I know, we don't have a date specific for the initial meeting, but we're prepared to do it whenever the commission would schedule it. We could have that when interested parties would need to have some notice of when it would be, but at that point, we, as you describe it, commission and consultants could meet with them and simply go over what we anticipate will be the scope of licensing evaluation process, and then request the submissions by them, not necessarily formal, but just so that we have in advance of the individual meetings their proposed tables of organization, funding sources, and so on, so that we can have a meaningful individual discussion with them about which of those persons or entities would need to be qualified, and schedule those individual meetings thereafter, after we've received their individual information.
On the scheduling, Chairman, I believe there was a date of October 29th floated around for the first meeting, the group meeting that you mentioned. I don't think has been said, but it has been discussed. And availability of the consultants, so we are available for that day.
So that would be a week from Monday, basically?
2 weeks from yesterday.
He's our
Yeah.
calendar man.
Right.
Yeah.
That's good. Is there, that's fine with me and us, but is there any need for less or more time? You know, we're on the one hand, everybody's anxious to get moving as quickly as possible. On the other hand, you know, we want to be thorough and methodical. That gives everybody who is a potential applicant time to get the forms in their final form, although most people have probably seen them anyway because they haven't changed much, and think about them, come to the meeting. Does that 29th sound right to you?
Yes, we feel it's a sufficient time.
Right.
And then
we could, if, as you say, if the interested parties come to that initial meeting with information for us, then obviously that would expedite our being able to schedule the subsequent meeting with them.
Right. So the subsequent meeting, you would suggest, be preceded by the submission to us of what exactly?
Of the table of organization of the applicant, and then its intermediary holding companies and the officers, directors, shareholders, the structure of their applicant entity, basically.
Okay.
So that we would then be able to meaningfully have a discussion with them about which parts of that entity would need to submit applications.
Right.
And which individuals.
Right. So would that be essentially giving to us what they think their qualifiers are?
That would be giving to us what they propose their entire structure is.
Right.
And then we would be able to then
Go with them
hopefully
on-
identify the parts of it
Right.
that we're most interested in.
Okay. And there could be as many as, we don't know how many, 8 to 10 such meetings, if there are 8 to 10 ultimate bidders. Are you all available, from the 29th on?
Yeah.
Sure, we can make ourselves available, and there's no reason why we couldn't have 2, 3, 4 meetings in a day.
Right. So we could take the week of the 29th, start out with our general meeting, but start now, if people expressing interest, that they know they're going to want to schedule time subsequent to the 29th.
Yes.
Tuesday through Friday of that week, basically, to
Sure.
start setting up the individual meetings now.
Absolutely.
Okay.
I mean, again, the experienced companies will have a lot of this information ready
Right.
and available, and they bring it, and that would certainly make it
Right.
most efficient.
Right, okay. Well, that sounds like a reasonable schedule, and that'll give everybody 1 week, basically, to get the final forms and think about it before the group meeting. It seems to me maybe it would be a good idea to have that, oh, this is a question. Should the Monday meeting, the big meeting, the open meeting, the public, the general meeting, be a formal open meeting? It would make it easier for more than 2 of us to attend if we wanted to. Does any of you have thoughts on, anybody?
There would be no, I can't perceive any problem with that. We would not be discussing at that general meeting the specifics of anyone's particular application.
Right.
That would not be appropriate in a public setting at this point. But as long as it's just an overview of what we anticipate the process being, that certainly would not be a problem.
But people might be asking questions which would require clarification, which might be something that the consultants can say, or it's possible, I suppose, that they might need some clarification that the commission needs to speak to.
Right.
We could field those questions.
We could
Bring-
right.
Bring them back to you
Yeah.
all, obviously. It would be,
Well,
there would be no decision-making perhaps at that meeting.
But we'd have a public, yeah.
We'd have a public meeting scheduled
Right.
the 30th anyway.
Right.
So that would be an alternative. If there were questions that needed clarification, we could do it the next day.
Right.
So,
Right.
do you have any instinct, Commissioner, as to whether it would be
I think it'd be helpful to have
prophylactic?
it, A, prophylactically, and B, to pick up nuance and other things, to have a public meeting, and we could be there and provide whatever instant decision-making was feasible. I suspect there won't be much, but there may be some, and we'd have an opportunity to see and get a feel for the kinds of questions and concerns people have unfiltered.
We don't want to give you the impression that this would be an overly formalized or
Right.
even extensive meeting. It might
Right.
take less than an hour.
Right.
These are people who've been, as Commissioner Cameron said, these are people who have been through this process, most of them
Right.
many times, and they
Right.
understand it. But for the reasons that you've stated, it certainly would be worthwhile to do it public.
And we don't want to leave any impressions on any of the applicants that the final decision-making with respect to scope of licensing is going to be decided on that day.
No.
And this is just a preliminary overview of the process
Right.
to be communicated. And it's primarily for the benefit of new applicants, applicants who have not participated in the licensing process in other jurisdictions.
Right.
And some of the applicants are well-versed in this.
Yeah.
And may feel it's not necessary to attend.
Right.
Right.
Well,
One more,
Yep.
if any, in order to move this along even quicker, if any of the potential applicants or applicants would be prepared to provide us with material on that day, we could, after the public session, schedule meetings with them that day.
yeah, okay, that day, yeah. Yeah.
Yeah.
If we had the first one in the morning, we could start, yeah. Okay, so let's, just to recap this, so we will schedule probably in the morning of Monday, the 29th, a open meeting to applicants. That will be a general, where for starters, the consultants will provide an overview of the process, and there will then be an opportunity for applicants to ask questions about the process. I think I agree with Commissioner McHugh that, there's no downside to making it a public meeting, and it might cover us in case we want to talk about something that we otherwise couldn't talk about. So I think we should make that meeting a public meeting. And it lasts as long as we should have it like 10 or 10:30, something like that, and it lasts for as long as it takes. Maybe we could ask people to sign up so we have some idea what kind of attendance needs we're going to have. Maybe we can do it here, maybe someplace else. Then applicants can tell us now if they are going to want to have a private meeting to talk about the qualifier situation. And you've heard what is required, basically the overall entity that will be the license applicant, and all the various participants in that, which will be the main tool main instrument that we'll be talking about. And starting any time now, we could be contacted by applicants who want to set up those private meetings, so long as they can get to us that entity structure in advance.
Okay, perfect.
Okay, and that could start as soon as, say, mid-afternoon on Monday, the 29th. giving us 3 or 4 hours possibly for the first meeting, and then Tuesday, Wednesday thereafter, 2 or 3 meetings a day, for as long as it takes to get all of the applicants who want those meetings set up. Does that sound right to everybody?
Sounds reasonable.
Perfect.
Okay.
Now, just to put a degree of nuance on the second part, the private meetings are going to be meetings between our consultants and the applicants. Is that the contemplation?
I wouldn't necessarily limit it to applicants. We would, that's up to you as a policy matter, but we'd suggest that interested parties, rather than, it wouldn't be required that they had filed their $400,000 at this point.
Yeah, yeah.
If they want to know more about it, so they can make a decision whether or not to apply.
Precise, that's an important correction. But I should have been more precise in what I was saying. Those meetings will not include us.
Individually, I mean, if, it might be suggested that a commissioner at least one attend at the meeting so that there's, direct representation, but that would be entirely up to you.
That's within your discretion, but certainly not as a group.
Okay, the reason I asked that question is that parameters for the application are going to be set at those meetings. Flexible parameters, parameters that may have to change as the investigation proceeds, but at least the initial parameters for the application process are going to be set at those meetings.
Mm-hmm.
That is not going to be a setting that takes place with a full vote of the commission. That's going to take place as the consultants shape the initial filings by the applicants or interested parties. And I raise that because it seems to me that we ought to formally authorize our consultants to shape, subject to any appeals to the commission that may ultimately be taken, the form of the application at those meetings, and empower them to do that with the understanding that any disagreements or differences that they're not able to solve can be brought before the full commission for approval. So I would, after discussion, if we want to talk about that a little bit, after discussion, I would make a motion that preserve that authorization so that it was part of our official action. And we're not going to be, 2 of us are going to be missing next, or absent on business next week.
This wouldn't be next week with us.
No, but in terms of trying to do it.
Oh, set this up, yes, right.
I would agree with the notion of empowering our consultants to do just that, but I would also like to see some representation from the commission, perhaps if it's in the form of one commissioner, to comply with all our other open meeting law requirements. That would be very important for me.
Well, I just want to raise one point, and this might help in terms of whether you think a commissioner needs to be present. And to be optimistic, we'll be able to come to an agreement with all of the applicants, but based on prior experience, that's not likely. There will be items of disagreement where a potential applicant is going to want to present their case directly to the commission in a somewhat adversarial setting, since the consultants are recommending that company X needs to file as a qualifier, and the applicants are saying company X does not need to file. The commission will have to make that final call. If a commissioner is present during those discussions, there'll be some level of commission interjection at that meeting, and I'm not sure that's necessarily appropriate. And in the past, in following this protocol, commissioners have not been present during these one-on-one sessions.
Is the timing of our hires of some legal staff appropriate to have legal staff sit down?
Legal staff would be
Legal staff
appropriate.
would be
Legal
appropriate.
staff, if you had a general counsel, for example, would be entirely appropriate.
I had the same concern about that. Would it address that concern if there were commissioners in the room but not participating in the discussion?
It would lessen the concern, but I don't think it would eliminate it.
Right, I don't think so. I know an applicant may feel that the presence of the commissioner is tacit approval of what the consultants are recommending and may hamstring them in their approach. I personally would advise that staff be present if that was, you know, practical.
I think that's right, and this is sort of the opening of a window on a variety of things that are going to happen as we begin to move forward into the commission processes, and being present at the discussions that formulate the issues that then are appealed to the commission is, I think, potentially putting the commissioner who attends in an awkward position, both in terms of appearances and in terms of prejudgment or judgment on the basis of facts that aren't in the possession of other commissioners. And so I think that I think it's probably better that the commissioners don't.
Fair enough, I would agree with that, but would still like presence of staff to go to these meetings from the commission's perspective.
I agree with that. I'm not sure how we're going to do that, but I think that's important. And I am reminded, as this comes up, that I forget at which stage of the process, it may not be at this stage, but it's very soon, it's the IEB that has the authority to do the background checks.
Right.
Maybe not these preliminary conversations, but we need to constitute the IEB. We won't have the director of the IEB on board yet, probably. But it needs to be constituted in order that we can have them start the work, and they can then at least partially delegate the work to the consultant.
Right.
What structure do we use to do that? We probably ought to do it sooner than later, because the process is going to start on Monday. We could.
We can take the applications without starting and set the scope of the licensing without starting the investigation.
Absolutely.
Is it definitely starting the investigations where the IEB has to be operative, or is it in this stage of the qualifier discussions and so forth?
I think the qualifier discussions can be done prior to the IEB's
Okay.
constitution.
Okay.
Yes, I agree.
Statute, I think, is pretty explicit about the investigation piece being done by the IUB. So we need to have some ability to create an IEB entity before we start the actual investigation. That doesn't prevent us from accepting the applications. It doesn't prevent us from talking about the scoping before we start the investigation.
Right.
And it may be, given whatever progress we're making on the staff council front and others, that we can do that in fairly short order.
Yeah, we might have a deputy director, the director of the IEB by the time the investigations start.
Right.
But we probably ought to talk to either these consultants or Anderson and Krieger about what do we have to do to constitute that. If not Tuesday the 30th, at least the week thereafter.
Right.
And the state police has already designated a major to oversee gaming. And that person would be available certainly to help stand up the Bureau.
Okay. Is the meeting on the 29th, we've talked about this, we're going to make it a public meeting, a formal public meeting. We will be inviting prospective applicants to ask questions. Do we want to make it open to others to ask questions, other interested parties? I would think.
As a public meeting, I would suppose the public is
Well, no, we don't have to.
invited.
We don't, oh, they're invited, yes. I meant invited to speak, sorry. They're definitely invited. But do we want to make it public that if other people, municipalities, interested parties?
This is really directed at the interested parties themselves, rather than you can get into some extraneous issues that really would not be that productive. It certainly might be worthwhile to the parties asking them, and they are entitled to ask them at the appropriate time. But this, at least in our view, I think, would not be the appropriate time for that. This is fairly limited in its scope, so to say, of what would be discussed, and it would only be relevant to those who have an interest in applying.
I think we could emphasize certainly at that meeting that the comments and questions and the like having to do with the application process and the scope of licensing or anything are welcome on the way we've been taking public questions all along, and that we'll
Right.
answer them diligently, and if some issue arises that we need to discuss as part of our discussions, we can do that, and therefore achieve the kind of public input without extending the meeting and getting into irrelevancies and
Right.
maintaining that transparency. So,
Seems right to me. Anybody else? Okay. Okay, so that's quite a bit. I think we should make our chief of staff the contact person for people, or her designee, for people who want to schedule meetings or are going to come and set up the 30th, set up the 29th, and so forth and so on. Anything else for our?
well, I think, coming back to the way the initial issue, I think we need to empower the consultants to conduct those meetings subject to appeal in accordance with our now issued regulations to the commission of any disagreement. So if there's general agreement on that, I would therefore move that the...
So, excuse me, just one
Yeah.
second. We're going to have some staff representation, hopefully counsel of some sort from the staff there. Does that change at all? Is it the dynamic of that empowerment? They're going to be, are we in fact delegating that away, or are we delegating it away subject to the approval of our council, or is it
No,
just,
we're
just delegating?
Delegating it subject to appeal to us. That's
Yeah.
the way it's going to be anyway, whether even in a steady state or solid state or whatever you call that, when we finally get there.
Right.
That delegate sets the initial steps, parameters. We take the appeals, we resolve.
Right. Okay.
And so that's the way it'll look at the finished product as well.
Okay. Okay, good.
So I'd move that the commission delegate to the firm of Michael and Carroll and the firm of Spectrum acting together to conduct a meeting on a date to be selected for all interested applicants to set out a general scope of licensing process, and that they thereafter, in the fashion they elect, conduct meetings with interested parties with respect to individual scope of licensing issues, subject to an appeal to the commission in accordance with the commission's now existing regulations of any areas, questions, issues as to which there is a disagreement between the interested party and the consultants.
I'll second that, but I'll repeat it.
Any further discussion on the issue? Does that work for you all?
Yes, absolutely.
Yes, that'll work.
Okay. All in favor?
Aye.
Opposed? Ayes have it. Okay, anything else on consultant status report, out-of-sequence policy decisions, RFA 1 process and schedule? So we will post the RFA 1 on our website. That may be, how do we do that? You may access it for a license application for.
I think the way we do it is, because this is all going to be done electronically, the medium is going to be, the application will be posted, the specimen application will be posted with the blackouts, i.e. the things we consider presumptively confidential. And the applicant simply, or the interested party simply downloads the forms and proceeds. So that tomorrow, we put up a notice to the public that we are now accepting applications, RFA 1 applications from those who are interested in a slots license. And then and that's what the notice says.
But the issue is issuing the RFA, not accepting applications.
That we are issuing we're issuing the RFA and accepting applications for. I mean, that's the wording of it. And then on Friday, we say we're issuing applications, an RFA and accepting applications for Category 2, Category 1 licenses.
But anybody can access our website and download the thing,
That's
whichever
right.
one
That's
they're.
That's right. But we haven't, they can download the drafts now, but we've formally issued, by doing that, in accordance with our vote that we just took a minute ago, we're formally issuing, by the posting, our RFA 1 application for the slots parlor, and only for the slots parlor tomorrow.
Okay.
The record will be clear that that's what we've done.
Okay, so when we post that on Wednesday and then again on Friday, just need to have accompanying language that makes that clear that we're complying with this vote of the commission to sequence it in this way.
That's right. We'll also advertise it in newspapers, which also we're required to do.
Right.
But we'll take steps to do that.
But the advertising in the newspapers doesn't necessarily have to be sequenced.
Nope.
So, okay.
Chairman,
Yeah.
may I suggest that in your notice, that you also provide a contact person available to answer any questions that may arise?
Yeah, the instructions now are going to direct, and that'll be part of the instructions.
Yes.
A person who will be the gatekeeper for the questions for the moment. We may change that later, but there is a gatekeeper listed in the instructions, and that person will see to it that the questions are filtered either to you or to some commissioner or to somebody.
Who is that
Jamie.
Jamie?
Yes.
Yes.
Okay. Okay.
Just want to give you home numbers.
Should go
Steve.
into an email box.
Yeah.
I'm
An
sorry.
email address.
Yeah.
It's the Point Pleasant number. That's an operation.
Chairman Steve offered his home number if you'd like.
It's his cell phone back.
Okay, anything else on all this? Thank you all very much.
Thank you.
Thank you. Very exciting.
Yes.
Okay, 3D is a PMA Consultants update.
Scott and Angel.
Sorry?
Scott and Angel.
Yeah. Would you introduce yourselves again? And
Sure. Good afternoon, it's a pleasure being here again. I'm Scott Libby with PMA Consultants. I'm the project manager for the assignment. Along with me today is Angel Avello, who is going to give the commission a brief update since the last time we spoke to you on September 25th, some of the accomplishments of the schedule, and then a 4-week look ahead. You should have a brief memo-type handout that he'll speak to.
Yeah, 2 handouts. One is 11 by 17 printout of the schedule, and the other one is memo type.
Yep.
I'd like to use the memo type format going forward. I think it's a little bit easier tool to communicate progress to you and look ahead versus the graphic. Graphic speaks a little bit more technical nature, but we're obviously open to suggestions, whatever suits the commission.
Okay.
I'll turn it over to Angel and
Sure.
begin.
Good afternoon. As Scott pointed out, the last time we gave an update to the commission was back in September 25th. Back then, we explained the roadmap to the February 2014 date for the Category 2 license. Right now, we're still shooting for the same date, going through the publishing of the RFI for the Phase 1 applications, going through the scope of licensing. That kicks the actual applications, and that would lead to the background investigations, review with the Mass Gaming Commission, hearing periods. Then that would jumpstart the negotiations and with the surrounding communities and the hosting communities by referendum, and that would lead to the final review of the commission and award of the first license. That's basically the critical path that is, if you will, the activities that are taking the date out there to February next year. One thing that we wanted to mention is in the last couple of weeks, we've been working with the commission, with Commissioner Zuniga, with Eileen Glovsky, and in contact with some of the gaming consultants to trying to review some of these durations, especially for the Category 2 license, to see if we can beat that February date and bring it a little bit earlier. We're still reviewing that, and we're looking for opportunities to make that happen. Hopefully in the next couple of weeks, we can have at least a draft of that. As Scott pointed out, we drafted kind of like a memo to use as a cheat sheet for the schedule, kind of like a bullet point. We wanted to touch base on the kind of like the progress, the milestones we have achieved in the last couple of weeks since our last update. And we actually want also to give you kind of like a preview what's coming in the next 4 weeks, kind of like a 4-week look ahead schedule, if you will. In the last couple of weeks, we have achieved the hiring of the racing director. Originally, that was in our first shot. We were trying to get that by sometime early November, so we actually beat that by good 3 weeks. So that was definitely good news. And also, we started the public procurement of the investigation services. That's something that it's ongoing right now. And the other one is the publishing of the regulations phase 1 by the Mass Register. We were shooting for that for last Friday. For my understanding, that's going to happen, if not today, tomorrow.
No, the regulations were published and are now effective. They were published on Friday.
Oh, they did. Okay, great.
The
Yeah,
date was achieved.
That's a day we had it. Just I couldn't find it in their website. And talking to Commissioner Zuniga, he thought that probably that would happen tomorrow. But
Right.
if that's the case, that's great news.
Yeah.
Just to give you a preview of what are the milestones that we have scheduled for the next couple of weeks. Kind of like the high points, we have the strategic plan, as the gaming consultants just mentioned it, coming out today, tomorrow. We have the one things that needs to happen, kind of like on the critical path, those kind of critical activities that are scheduled for the next couple of weeks, is the publishing of the RFA process for the phase 1 applications. We talk about that hopefully tomorrow, and it seems like Friday is the second one. And also the drafting of the scope licensing for the investigations for the phase 1 applications.
This says drafting of the scope of licensing. Is there something to be drafted, or is this just the process of, scope of
It's
licensing?
just the process.
That's a good, yeah.
Yeah, okay.
I'll update that.
The determination of scope of license.
Right.
Thanks for that correction. Other things that need to happen to comply with the regulations, we need to start developing the RFA for the research agenda. Also need to, one thing that we expanded the schedule, maybe you can take a look at that in the second page of the printout. It's, we develop we call a fragment, which is like a separate kind of activities to track the internal hires in the Mass Gaming Commission that need to happen to support the application and investigation process. And one of the key things that we need to have in the next 4 weeks in order to be ready to support what's coming in the next couple of months is the hire of the ombudsman. We had that scheduled for this week.
It's actually.
My understanding that it's on track.
On the agenda for today, yeah.
It's on the agenda for today. I didn't want to give it up, but one thing that we also had there that we need to start working on is convening for the Gaming Policy Advisory Committee. We also need to continue the procurement process toward investigation services, the interview of applicants for the General Counsel and for the Executive Director position. And the other section, the last section we have in the schedule right now, that are big things coming our way in the next couple of weeks, is the drafting of the MOUs, especially the investigatory MOUs with the federal agencies, and the drafting of the other MOUs with other agencies, the interagency MOUs. That's in a quick overview of what the status of the schedule is right now, the progress we have made in the last couple of weeks, and what we're looking forward in the next 4 weeks.
questions or?
Something that we have, that is not represented yet in this schedule, but that this was not yet the intention, is thinking about resources that we will need we will need to staff up for the receipt of those applications eventually after we finish those investigations and the process for RFA Phase 2. In other words, we've talked a little bit about whether we need to procure advisors that will help us evaluate those proposals, the Phase 2 proposals. And I know part of that is a little bit contingent on the hires that we are indeed making now, like the ED and the ombudsman, et cetera. But because these procurements do take a bit of time, it's just something that we need to start thinking about, what those may or may not be.
I think this is, I have one specific question and a general question. What is the meet, host, and surrounding communities?
I think that's
what's the substance of that?
I think that's a process that we anticipated. I mean, right now the schedule contemplates a window for the applicants to engage with the surrounding and hosting communities and to hold a referendum. Well, we thought that although we have a specific window for that, the actual engagement with those communities, that process, that conversation will actually start happening much earlier than that. I mean, even without leading to a referendum, that back and forth, that engagement of the community will start happening as soon as possible.
That's for the applicant.
That's for the applicant, yes. Yes.
But as a practical matter, also, our ombudsman will be aggressively.
Right. Yeah, there will be more people involved to that.
Right.
We have a specific window for the actual referendum, for the actual application, but the engagement of the community will start happening hopefully early next year or probably in the next couple of months.
I understand that now. But my second question goes back to something you began with, and that is that in the future you thought it would be helpful just to have the memorandum. I really think that this is enormously helpful. And at one point I asked whether it was possible to have this entire thing available in a read-only mode on the shared drive or someplace so that we could go to it and look at it. As I look, for example, at page 2 with where we have to do the hiring and think about what that needs to support, that's a very helpful summary for the pieces that I'm engaged in to keep track of. And there are other things in here that are enormously helpful, both to see what deadlines are looming and to think about critically places where we might collapse things, and the graphic presentation, and then the look below at what goes into the top line graphic presentation is, I think, enormously helpful. So I would reiterate my question as to whether or not it's possible, whatever we do at these meetings,
yes,
possible to have this available in a read-only mode as it comes up, so that if you're working on this in late afternoon sometime, you can just go and see where the latest iteration is.
yeah, certainly, we can. It's easy enough. It's just this representation. We can easily dump this into Excel or any other format and put it more in a table format.
Maybe just to clarify, I wasn't looking to replace the schedule with the bullet point. I think more of a supplement. I think the supplement more is just a high-level discussion piece, but we fully intend on providing the schedules to you on a regular basis.
Yeah, I think the schedule gives the overall picture, from now until the first license. But the intent of the memo was to give a more concentrated view of what's happening in the next 4 weeks. What are the next the very milestones that need to happen in the near future.
A term we use in the construction business is roadmap to success. We take this little checklist, we set it up our meetings with our contractors, and we try to drive the priorities from the schedule. People look at the graphics, could be interpreted 10 different ways, try to set one general course of thought. So that's the idea behind the memo.
Yeah, no, I see now. And I think that's, obviously that works, and it's enormously helpful. It's also nice to be able to put that in the context particularly after the meeting when you're thinking about it. How
No, we
broad
can
a
certainly
picture.
share, we can certainly prepare kind of like a table format with all these activities and putting table, if that's helpful for everyone.
Well, this format, for me, at least, is fine.
Yep,
It's-
I'll make sure to send out an email when the recent update is there. I'll update and put it in the shared drive. I'll make sure that.
But you're training Eileen or somebody on our staff
We did.
to do
Yeah.
this, right?
Yeah.
Because in addition to the read-only, I mean, if we're sitting at this meeting or sitting at a update or whatever, you know, we may want to look at these things ourselves. So, and I think it's important to have, we were always intending to have you all build this thing
Yes.
for us and tell us how to use it.
Yes.
And then eventually to transition to have us be able to manage it ourselves.
Yeah.
And whether it's Eileen or somebody else, I think that's an important transition.
And we have that capability now.
Right.
Yeah.
Okay,
As
good.
well.
Yeah, I do.
The one thing that would be great to add on to this, and you could get it by talking to Janice, is our space needs. We know we've outgrown our space, and we're on a timeline. It's going to be absolutely critical path in about when do we get the space built out so we can put in the new people, and that would be a good addition to this.
Okay. Yeah, we can certainly, who would be the right person?
Janice.
Janice, but I can,
Yeah, I would have a couple of updates too. One would be the IEB
Okay.
hiring process, which is ongoing now as we speak, interviews, whatnot. And the other would be, we're just about to start a process where we're going to be looking at our simulcasting and parimutuel wagering.
that is on the first page.
Is it?
Commissioner, yeah,
Yeah.
it's this little blue, little process here at the, right under the summary.
In blue?
You mean the statutory process?
Yeah, the statutory and regulatory changes.
Statutory and regulatory changes, okay. So that includes all of them?
Yep.
But if you certainly have more detail than that, we can break it down. I mean,
Because we'll have real deliverables there to
and
want to make sure
that would
we-
be very useful to have in there.
We could expand on these, but it's represented here.
Okay.
And Jennifer may very well want to add into this the
More
task,
racing
the
DPS.
task force, all the stuff, the implementation of the
Yes,
new everything,
agreed.
you know, that would be a great thing.
We'll coordinate with Commissioner Zuniga and have a separate discussion and meeting if need be.
Good, that'd be great, thank you.
Anything else on this? Thank you, it's a great document.
very
Thank you, yeah.
Thank you.
Thank you.
I'm going to ask for a quick recess. We can come back in 5 or 10 minutes. All right, I'm ready to reconvene our meeting number 31 on October 16th. On 3D, there was one other item that drives out of the timeline. Commissioner McHugh pointed out that we owe an annual report pursuant to the legislation. He did a draft, which Elaine and I have looked at and made some edits to. I think it's pretty close, but if you either have, if anybody has anything particular to talk about it, I think it's really just meant to be a progress report, which is the way maybe in the future we'll flesh this out a little more, but right now we're just trying to comply quickly. Did anybody have any comments, or does anybody want to just send updates or additional items about what we've done in the first few months?
I'll just throw one thing for consideration. I don't believe it's particularly imperative, but if we wanted to include any kind of reporting relative to financial expenditures, I will also speak to that
Oh, no, that's a good point.
briefly
Yeah.
in the next point.
Okay, actually, after maybe you could just send me, fashion it somewhere. Maybe it's a second, maybe it's another header, or maybe it's under, it's probably under operational initiatives. Just, if you could just send me a bullet point that suits there, great, that's a great addition. Any other?
Just two quick additions. As I was reading through it, I didn't know if we wanted to talk about, this falls probably under operational. Talking about the fact that we had the multiple location regulatory meeting, which probably is, I think we experienced, hadn't been tried anywhere else before.
I think that's here somewhere.
And this is,
Yeah, well, plan, produce, and live stream the day-long public conference. Is that the one you're talking about? The third bullet point on page 4. Sorry, Aaron.
Oh, I apologize.
no, I was.
Just a minute, could I interrupt, just so that we could get this back on track? I neglected to look in that direction myself, and so what we've done is reconvene the meeting and have just begun to take a look at the item 3,
D.
3D. No, that's.
Yeah, no, this is, it comes out of that item.
Oh, it comes out of the item,
Yep.
which any event, we've just begun to talk about the draft report to the legislature, and we're going through the draft report, have just begun that, and Commissioner Stebbins raised a point about a multi-location meeting being held, and Commissioner
Oh,
Crosby was.
hold on, I'm sorry. You're talking about the 3-site meeting.
The 3-site regulatory
Yeah,
meeting.
absolutely, good, right.
And then.
That was hearings on the regs.
Yeah, hearings on the RFA.
3-site hearing on regs.
That's
And
never been done before, I think, to my knowledge.
In the world? In the
No.
history of humankind?
Probably in the history of humankind, that's right, yeah. So I'm going bold.
And the fact we've also held 2 of our commission business meetings outside of Boston area. The other thought that occurred to me, especially under the operational initiatives, is there a way we can maybe segment some of the bullets into different categories? Like we have a couple bullets that are intermingled on racing, some on our hires, some on our contractors. If we could maybe kind of subcategorize those so they'd all be kind of lumped together.
Do you want to take a quick stab at that and
Sure.
send it to me? That'd be great.
Yeah.
That's a good idea. That may be constructive on the other stuff as well, just to make it easier to read. So if you want to look at more than just operations too, that'd be great.
Okay.
Anything else on that? Did we get all the racing stuff?
I think we're in good shape. The couple of bullets covers,
Okay,
gives us an idea of what we're doing.
okay, great. Okay, item 4, administration. Director Glovsky is out of the country. Personnel searches, I don't know that there's really anything to talk about other than what we've talked about, which is, as on the chart, they're all underway. Is there anything?
We posted
We'll
just.
get to ombudsman in a second.
Yeah, we posted a couple of positions for, temporary positions for specific project-based research, a generalist position. So that's been posted.
Right.
Director Klowski had already talked about it, but now it has been posted.
Right, okay. So we presently are looking for ED, Executive Director, Director of Investigations and Enforcement, General Counsel, Staff Counsel, what else?
Fellowship attorney.
Fellowship Attorney, the Ombudsman, which we'll talk about today,
Executive
hopefully.
Assistant.
And I'm going to report
Couple-
during my racing.
Couple of
report,
racing people, okay, and a couple of executive assistants. And also there is a staff generalist position. That's all. This is for the public. These are all on our website. These are all open searches. But there's a lot of hiring going on right now. Okay, anything else on administration? Finance and budget, Commissioner Zuniga, do you want to step
Yeah.
in?
Yes, I can first speak to what I submitted as part of the packet, a summary report of expenditures, the first quarter expenditures report. This is on a cash basis, so there could be certain costs incurred during especially the month of September, the last weeks of September, that are not yet reflected here because they have not been disbursed. We're not reporting on an accrual basis, this is on a cash basis. I've also submitted a budget to actual little summary report here as well for your consideration. I spoke to these last meeting, last week, that when comparing to the prorated budget, the salaries line item is underspent only by virtue of the fact that we're ramping up literally as we speak, as we were just talking about. But the other line items are tracking as essentially as projected. I can also take any questions, or also reiterate that a couple of important factors are not being reflected in the budget, but they never were. Those are the incremental costs of investigations, which are anticipated to happen, which will be assessed on the applicants. So there's not, I did not see a need to reflect them in the budget. As well as any expenditures relative to a research agenda that we have not yet ascertained or determined whether they would come from the Public Health Trust Fund or anywhere else.
If they don't,
Yeah.
it's going to be a bit of an issue, right?
If they don't, yes,
Right.
it would be a bit of an issue, yes.
Right. Okay. No, this is great to have. Have we, the statewide allocation percentages, that is a negotiable item, we understand, right?
I'm not sure.
Okay.
I don't know the answer to that question. The negotiable piece that you may be alluding to may be the difference between spending from an appropriation, which gets charged at 10% or so, or spending from a trust, which gets charged at a different rate. This is particularly important for racing operations because when racing came under the Gaming Commission, it lost the appropriation, but we have the ability to spend from the trust that was given to us, if you will, that we became the trustees of. So that delta really applies for racing. My understanding, and that of I believe the comptroller as well, is that we will be subject to this 10% statewide indirect allocation.
And what is that?
It's paying for the overhead of the Commonwealth. All agencies pay into the indirect costs, paying for our secretaries of state and things like that.
So you pay 10% of whatever you spend goes to this
To the indirect.
overhead?
Yeah. Now,
Isn't there a waiver that can be applied for with those costs?
not to my knowledge.
Okay.
I mean, one could make the argument that it's the state charging itself,
Mhm.
but nonetheless, this is a mechanism that they have come up with to distribute, to allocate among the different agencies.
Well, we don't pay for, other than through a mechanism like this, we don't pay for our payroll system, for example, right?
Correct.
And we don't pay for benefits management.
Correct.
There are a lot of services.
Oh, yes.
We don't pay for our, there are a lot of services.
All the IT stuff.
Indirect.
Some of the IT stuff, so.
Just that is correct technically. We do get certain chargebacks though, because there are certain elements that, depending on usage, we start to get certain chargebacks.
I think it might be a conversation that's worth having with A&F, just, so we see if there's any flexibility there. I've negotiated overhead rates when I was on the other side of the table.
I'm sure it's worthwhile.
Yeah.
My guess is that these may be especially helpful for the startup money that we were given, or especially worthwhile, I'd be, interested to see if that flies, if you will, after that.
Well, that's a good point. I mean, it's when the casino operators, are being assessed, in effect, to pay the expenses of the regulation of the casinos, it's not unreasonable that they pay whatever an appropriate overhead rate would be. But when we're borrowing money from the rainy day fund to get up and running, of course, that's all going to get paid back anyway. So I don't know. It's an interesting question, but it's worth a conversation, I think.
That's my point about bringing from one pocket and putting it into
Yeah,
another.
right.
We just have to deal with that.
Right. Okay. Anything else?
Yeah.
About that, on budget?
Yes, as part of that, I submitted a short summary memo relative to the contract extension of the gaming consultants, which I was given authority to negotiate, and I have summarized here for you. It has a budget implication, so I wanted to also make it part of the discussion under this line item. Both sets of consultants and myself, with the help of Director Glovsky, have a tentative agreement on extending the rate or their contracts, their ongoing contracts, as part of these ongoing help that they have for us, under the terms that I've articulated in this memo. There's a slight increase in the lump sum monthly fee that they had, that we have been operating under, because there's a recognition that there is more effort coming up as part of both, as part of everything that we have to do for RFA Phase 2. There's a number of policy decisions. There is anticipated that there will be more meetings and more travel, and we've considered that. I also wanted to mention that when I first drafted the budget, I had anticipated, because that was the assumption that I made, that such an extension would take place in 6 additional months. But given all the time frame that we have now come to understand a lot more of, we believe it makes sense to make that extension be for the remaining of the fiscal year, which is effectively starting October and ending June 30th of the following, of fiscal year 13. So this extension creates a bit of a gap, if you will, from a budget perspective, but I believe that we will be able to manage according to the same level.
What do you mean by a gap? Meaning because it's 8 months rather than 6 months, it's a bigger number than we had originally budgeted?
That's correct.
Okay.
That's correct.
But presumably that'll come out of next fiscal year.
That's correct.
It's not necessarily, you're not necessarily talking about more dollars in overall. You're talking about when they're spent?
Yes.
Right.
This fiscal year. So on my previous figure, on my previous report, the number for consultants that's part of the second line item that I budgeted here is a little understated, only for gaming consultants. There's other consulting work that's part of that as well. That's my only point. I don't think there's a need for a big budget revision at this point. I just wanted to make that part of our part of the report. So as I was intending with this memorandum was to submit for your consideration, discussion, and eventual approval or ratification, really, of what I've negotiated with the consultants, which is the monthly fee as stipulated herein for the summary scope of work that's also stipulated here.
Yeah, just to make sure that this is not something that Commissioner Zuniga has been doing on his own hook. There's been a lot of iteration back and forth to analyze these numbers and to think about it and make sure that we're on the right track. And I think that all of us who've talked about it feel comfortable with it. Are we ready? Are we ready to
I could take any
go
question.
forward?
Yeah, that was my intention. My recommendation is to ratify the tentative agreement with the gaming consultants to extend a contract for the amount and terms stipulated in the memos that I have put forward.
Is there a second?
Second.
I would just say, first of all, to reiterate, we've looked at these closely, and we have felt that we have gotten very good service from our consultants. They have never said, sorry, we can't do that, it's not in the scope. They've never said to us, yes, we can do it, but it's going to cost you more money. They've always been tremendously responsive and flexible, almost, I'd say, remarkably so. So I think the Commonwealth, is getting very good value for the money, and I think we've learned this is a business where you need to trust the people that you work with, you need to trust their discretion, certainly need to trust their integrity, but even more subtle issues of just nuance, and I think we've found them to be really reliable, high integrity, thoughtful people who have helped us go out of our way to they have gone out of their way to help us figure out what is the way to serve the public interest the best. So I for one, feel very good about having picked them. I mean, as everybody knows, they really were the two best companies in the country that we could come up with, and we put the two of them together to create a team with the help of Kathy and Kristen, and I think it's worked really, really well. So I'm very much in favor of this.
I agree with all that, and would just add a minor point, and that is that the initial contract did not include any effort directed toward the regulations, and the amount of time and energy that took is an ample basis for concluding that the more complex Phase 2 regulations are going to take an enormous amount of time and effort, thus justifying all by itself an increase in the fee that the consultants are being paid, plus the fact that the individualized interactions with the interested parties and the applicants are going to require, in all likelihood, an enormous amount of time as well. So I echo everything that Chairman said about the quality of the service we've gotten thus far, but looking ahead, it seems to me that the increase is well justified and will cover the significant added work we're going to expect of them over the next 8 months.
Anybody else?
Yeah, I would just reiterate all of those things and say that the personal touch has been tremendous. I know for me, finding out what others are doing in other jurisdictions to really evaluate our steps moving forward has been very helpful, and I know I pick up the phone frequently to ask questions, whether it be investigations or some licensing question, whatever it may be, and I always get a call back that day, and if research is needed, it's done immediately. So I'm very, very pleased also, and it's been tremendously helpful with my responsibilities.
Great. Anybody else?
Very pleased, and would say that even if they weren't sitting in the room.
So pass on those comments to your compatriots, please.
Yeah.
We thank you very much for this opportunity, and it has been our pleasure, and we've enjoyed it as
very well with the commission, which I believe is also a testament to what they are articulating as their intention to continue to do that, and the level of money that they're charging us for.
Yeah. And the collaboration between the two has worked out well, too, which is another, it was kind of an unknown. We threw together these two teams, and it's worked well. Any other thoughts? All in favor? Aye.
Aye.
All opposed? The ayes have it.
Thank you again.
Thank you.
Thank you.
I reiterate what I said before.
All right, good. Thank you. Thank you, Jim. Oops. Okay, where are we? You had some other topics?
Well, on topic on the budget topic, I will continue to monitor, but there is, I just want to throw one thing for early consideration. I don't think it's an issue right now. But one read of the legislation allows us, actually this is very clear, the legislation allows us to assess the commission's costs proportionately on the number of gaming positions to our licensees. I happen to believe that that is probably a very straightforward way of assessing costs proportionately. And I could go back to the specific section, but if that means, if one read of that means that we can only assess those costs until there's a gaming operation, meaning table positions or slot positions, we may have a problem in terms of funding between sometime in the near future and that point, which is in the farther future. If, however, we have the ability to assess on the projected positions, which is what would be my read.
Really?
Then we are trending okay relative to our expenditures, because what we're Angel was describing on the slots parlor license, then we are in general a big picture. So far so good with our expenditures. Now our expenditures are going to grow, and there's a number of things that are going to happen between now and the issuing of licenses. But nonetheless, I wanted to bring that up for general awareness because I think it's important to consider.
Does anybody have, Bob Carroll or Commissioner McEwen, may have a read of that legislation off the top of your, Bob, not Bob, Guy and Bob, sorry.
It's section 56, small section 56. I can quote you directly if you're interested. It doesn't address your question.
Go ahead.
Any remaining costs necessary to maintain regulatory control not covered by the fees of the slots parlor or the rainy day funds submitted to us shall be assessed annually on gaming licensees under this chapter in proportion to the number of gaming positions at each gaming establishment.
So what's the issue?
Well, the question for the moment that's being raised is, does that become operative once somebody is licensed with a certain number of gaming positions? From that point forward, they can be assessed, or does that become operative only when the gaming positions are up and running?
I have a personal view, but I think this is the kind of issue that if discussed sort of from the hip is likely to create concerns that may not otherwise exist, and that we'd do well to take a close look at the statute, its context, and think it through, and then make a reasoned judgment about where we are. It's an interesting issue.
Need to do some more research.
Right, and I think you're raising it because you want to get it on the table, and
as early as possible.
There are other issues in our funding schedule that we need to think through, and it's never too soon. So, thank you for bringing that in.
No, I think it's important to think about it.
We will, get some legal advice and so forth, and think about that. That's a good point.
That was it for budget update. I had a couple of other things for procurement update. Sorry. The Commission will recall that I was given the authority to negotiate a sole source contract with the consultants for the purpose of conducting the investigations of suitability. I took a look at the time frame that our schedule allows for, and I believe that there is enough time for us to conduct a competitive procurement and get the comfort level that comes with that. So I wanted to report to the Commission that an RFR has been posted for investigations, and we hope to get responses very soon and in time for the Director of IEB, who will be upcoming, and the responses that we get from prospective applicants.
Right. Commissioner Zuniga and I did discuss this, and it seemed like as long as we were all concerned for a lot of reasons, particularly time, and as long as we could do it within the time frame to get a competitive procurement, that was clearly the preferred way to go, and we felt that was within his authority to go ahead taking that kind of a move. But it probably makes sense to have us ratify his action. It's up. The RFR will be up for 10 days, and it's been widely distributed. And we will then move very quickly to hopefully be ready to go on or about the same day that the completed RFA1s come in. Do you want to move to ratify your?
Sure. If there's no more questions, I'd move that we continue with the progress of the RFR that I have put forward and look to see responses that might come in and have this commission ratify this approach for the procurement of investigations, the competitive procurement of investigations.
Second.
Any other discussion?
Well, we discussed this at some length at one of our prior meetings, and we took a different course at that meeting. So I think it's fair to say that having thought through and considered, as the chairman and Commissioner Zuniga did, the desirability of proceeding with a non-competitive approach to this, for the reasons that we discussed, which we initially decided to take for the reasons we discussed at some length at our prior meeting, that this is a change of direction in favor of a competitive process, and is designed to ensure the kind of transparency, notwithstanding the fact that we're authorized to take a different route, we're authorized to take the non-competitive approach, that we're taking this approach in an effort to continue the transparent way that we've been doing things from the outset, and ensuring that the appearance of transparency as well as transparency is there. So I am in favor of revising our prior approach and understanding the sound reasons that we had for taking it, and following the approach that we've now decided to undertake.
All right.
And I know that Commissioner Zuniga has spent a lot of time and effort on this issue, as he does on every fiscal issue. And I respect his judgment and certainly his expertise with this matter, and defer to his good judgment here.
Thank you. Yeah, and my 2 cents too is that it's clearly better always to do a competitive procurement where you possibly can. We clearly are authorized. There's no question about this. If we feel like it's in the Commonwealth's interest for us to do the job, to have some other kind of a procurement, but where humanly possible, competitive is clearly better, and that's what we decided to do. So I think we're all on the same page on that one. Any other discussion? All in favor of the motion?
Aye.
Aye. Opposed? The ayes have it.
Just to round up the procurement discussion or update, the stenographic services RFR was issued, and responses are due on October 26th. And we also received 3 responses for financial advisory services that we solicited. They're thoughtful, and I don't know if you had contemplated, Mr. Chairman, discussion about that, but I just wanted to give an update that those responses came in, and that's positive because we got 3 of them.
I think, absolutely, because we need to resolve this. We've been talking about it now for quite a while. And just to reiterate, we did decide, we made a tentative decision that we thought finding a financial advisor who could help us talk to the financial markets to facilitate the financing of anybody who's interested in coming to Massachusetts in a gaming facility, and maybe to increase competition for the licenses that are up for grabs, was a good idea. And we've gone back and forth on this. We got these 3 proposals, and we've continued to think even as we've reviewed these. And I think that my sense is at this point, but I'm not made up. My mind is not made up on this. But on the two issues. One is, is there anything that we can do to encourage and facilitate the financing of these deals for the folks who want to do business in Massachusetts? And I think the general consensus is that what we can do to encourage financing is to have a clear, understandable, predictable, reliable, stable process, which is above reproach. And if we do that, which is what we are in the process of doing, the financial folks will be there, whether it's equity or debt. And to think that we, under this time frame, can add very much trying to appeal other than reiterating the clarity of our process, I think is illusory. That there's not much we can add there, particularly given the time frame. On the second issue about encouraging competition, particularly with the issue in Eastern Mass, we have all been very straightforward in saying that our job is to get the best deal for the Commonwealth, which meaning the best economic development, the most jobs, the most revenue, and the minimal negative consequences. That's our job. To do that, competition is a plus. And we have said repeatedly, look at Western Mass. The first bidder came in at $800 million. The second bidder came in at $807 million. The third bidder came in at $900 million. Those folks are putting their best foot forward. It's a competitive environment. That's what America's all about. That's what the legislation anticipated. So to the extent that we can promote competition, that is clearly in the public interest. And I think we've made a point of going out of our way to make it plain that there are nothing is certain out there. This is a level playing field. Nobody has a leg up over anybody else in terms of our judgments. But if anybody's listening, they can tell that this is an open field. Western Mass is open, Eastern Mass is open, the slots parlor is open. And if anybody's listening, they know that we are anxious to have multiple bidders for all those licenses. To think that we can do much more than say those things repeatedly in the various ways that we have in official meetings and unofficial meetings, again, is illusory. I don't think, I've come to the conclusion that there's really not very much we can add. So I have sort of reluctantly come back from the idea of thinking that it's worth doing this. The other side of it sort of is, hey, there's no downside except to spend some money, and it's non-trivial money, and maybe we do something good, but we got an awful lot going on here, and for something which has, I think, a minimal chance of real positive gain, I'm not sure it's worth it. That's sort of where I am at the moment.
I think that's well summarized. I feel pretty much the same way. I was originally thinking that there could be a real value in spending some money to explore, who the players, what other factors may be, what players are missing, etc. from the Eastern Mass section, but it's not clear after going through the responses, which are insightful, and I can speak to them in a few minutes. it's not clear that there will be a lot of gain for the commission for these if we conducted this exercise. There would be one valuable thing, I suppose. One of the responses suggests conducting a survey. The amount or time or level of that survey remains to be seen as to how effective that could be in letting us know the factors that are contributing, but certainly not determining one applicant for Region A. That could be an exercise in just finding some insights, not necessarily changing or affecting the field. So.
I haven't had a chance to read these. I was away, but from the outset, but the analysis you both have given strikes me as a sound one. We've got a lot going on. The incremental value we could add to the process by engaging these kinds of efforts strikes me as low. And this expenditure of money, even somebody else's, is not something we ought to do just because we can do it. I take it that we will revisit the idea of a financial advisor in connection with analysis of the RFA 2 applications, or even the RFA 1, but this is not aimed at that. So
that's definitely accurate.
Right.
Yeah.
That is definitely one of the responses. Certainly alludes to that. Actually, two. That there's real value for the commission in understanding the financial assumptions behind the proposals that will come to the commission after that phase 2. But the early efforts, if you will, that we initially contemplated is less clear about their marginal value.
I thought the most persuasive statement came by the chair when he said we should focus on what we need to do moving forward, the licensing process, the investigations, standing up the commission, and some of the ancillary things sometimes can distract us in figuring out what is essential, is important, and that was very persuasive to me, that we really should be focusing, especially where there's a low probability of it being effective. So.
I also just echo the chairman's comment about probably what any developer and any other financing sources would be looking to is how credible our plan is and our timeline is, and our ability to meet those timelines probably helps them more than anything else we might be able to do at this point. In terms of the idea of the survey to see why we got competition or didn't get competition is an interesting suggestion, but I'm thinking maybe we're somewhat past the time frame of where that might be valuable to us. But should we consider at some point if a potential licensee would approach us for our help in having those conversations with potential financing sources, is that something we ought to consider down the line?
If a licensee were to approach us, I would say, sure, we would, be sensitive to whatever the issues are, but we would certainly, once a licensee comes in, we'll still be regulators, but they'll be our partners, and we'll be wanting to do everything we can to support them. So I would say, sure, in that environment.
One of the insights that I gained from reading and thinking about these is that what the chair also described relative to the money will find the deal. It's not really the other way around. The financing may not necessarily by itself generate a deal. Which was perhaps a very, very early assumption about when we started to think about the so-called trip to Wall Street. Wall Street will be there, and even those outside of Wall Street will be there for operators who have a good proposal.
Right. And even the fact that we've been talking about, so we've gotten feedback just over the course of the last month and a half that even as we've been talking about this, people have heard. And it's, just for the record, this commission believes that competition is in the interests of the Commonwealth. Nobody has a lock in Western Mass. Nobody has a lock in Eastern Mass. Nobody has a lock on a slots parlor. We are open and anxious to have aggressive competition for all of our licenses. And that is a message that we have given before, and we will continue to iterate. But I think this means of pursuing that is probably not the way to go. Okay.
Right. That's it for procurement.
You done?
Yep.
That was quite a bit. Commissioner Cameron, racing
Yes,
update.
Mr. Chair. As part of my responsibility that was designated to me by all of you for racing, one of the issues I dealt with is an issue that the kennel owners brought to me soon after, and I prepared a memo just outlining some of the basic facts in this matter. And I'll just briefly summarize this, and it's really a tentative decision, and I think we should all vote on here. And the issue brought before me, I thought of them as legal in nature. They were interpreting the law, these issues, and monies that the kennel owners thought were due to them, and Consumer Affairs, who had responsibility at the time, interpreted the law a little differently. And as we know with any law, sometimes things are a matter of interpretation and can be interpreted differently. But because it was a legal matter, I thought that our legal counsel should be involved. So at my request, Ms. Nina Pickering-Cook of Anderson and Krieger assisted in an informal, they brought me these concerns informally, they being the kennel owners, and I suggested to them that certainly I wasn't going to make a legal decision or make recommendations to the full commission with regard to a legal issue. So we would have an informal meeting in which each of the parties could lay out their concerns. So we had that meeting, and both parties just explained their concerns, and the kennel owner's main concern was it had to do with unclaimed winning tickets, which are commonly referred to as outs monies in the greyhound racing world. And these were monies from 2008 and 2009, which ended up in the Racing Stabilization Fund as a result of the legislation. They thought that both of those years, the monies they were entitled to. We had our, like I say, Anderson and Krieger assist us with this, and I believed after reading after listening to the presentation, after listening to our legal counsel, that in fact the 2008's monies, the kennel owners and their representative made a persuasive case because the law was not enacted at that time. The law wasn't enacted until a month after those monies would have been due to them. But with the 2009 monies, in fact, the law was in effect, and those monies should have and did rightfully go into the Racing Stabilization Fund. So it is my recommendation to the full commission that we pay the owners, the greyhound owners, kennel owners rather, for those 2008 outs monies, which are now in the Racing Stabilization Fund, but that the 2009 monies were put in there as the law required. The last issue that they brought before us was an issue around simulcast monies that were that are paid into the Racing Stabilization Fund. The kennel owners believe that both Suffolk and Plainridge should be paying into that fund because they simulcast greyhound racing at those facilities. And again, research In looking into this matter, the law does not speak to the monies going into that account, only coming out of that account. So the representatives have been advised that that would be an issue that they'd have to take up with the tracks themselves if they think that they are owed monies. Mr. John O'Donnell is the spokesperson for the kennel owners. He was appointed to that role by the rest of the kennel owners, and he's been verbally advised of the findings here and the recommendation that I'm making to all of you, and he has had an opportunity to speak to, and he knew that the other alternative to this would be he could come before the full commission with this matter. It's my understanding that they have decided that we made a reasonable settlement offer to them. They understand the issues and are willing to close this matter by settling with the 08 outs monies, and they're willing to sign a written agreement stating same. So it is my recommendation that we vote on approving the 08's outs monies, that we will make payments to those kennel owners. There are 22 of them, by the way, and we're talking about approximately $500,000. And we do have the breakdowns of the kennel owners and what monies would be owed each of them. So it's my recommendation that I make a motion, actually, that we pay the kennel owners for the 08's monies. The 09's monies are in the account and should stay there. And that could take place after the individual owners sign an agreement stating same.
So this effectively becomes the last payment to the kennel owners?
There are other monies that are legislated,
Okay.
but this was an issue that they brought to our attention, to my attention, which a decision was made that they disagreed with. The other pieces of the legislation, there is no dispute with those payments. The payments will stop in 2014.
Just for my edification, is part of what may have been a different interpretation here, the fact that the unclaimed tickets have a duration of a year, if you will, that it takes a year for them to become officially unclaimed?
It's really almost 2 years later in which they are paid. But
Right.
yes, you need to give the individuals who actually won a year to claim
Yep.
before that becomes what is commonly referred to as the outs monies.
The outs, right.
I think, and correct me if I'm wrong, Commissioner, that part of their claim, in addition, that the Department of Public Utilities licensure claim was that by the time the legislation went into effect, there were no purse accounts left into which to pay the money because racing had been abolished before. So there was no place to put the money. You can put the money in the pocket of the kennel owner. It doesn't have to have a purse account. So I think that was part of.
That was part
Yeah,
of it.
I believe this
Correct me
was,
if I'm wrong.
I think
Yeah.
you're absolutely correct, and this was a good faith effort on the part of Consumer
Right.
Affairs, who handles the financial matters. Department of Professional Licensure uses Consumer Affairs for all their fiscal issues. They do not have their own fiscal people. So that's why the decision was a consumer affair decision to be made, and I do believe it was a good faith reading of the law and interpretation. But because the responsibility was ours, I felt like we needed to take a look because they brought us this issue and did that in conjunction with Anderson and Krieger.
And those monies went to this Racing Stabilization Fund
Correct.
and are really effectively residing
Correct.
there.
Yes, they are.
Okay, any other discussion?
Did you intend to include, Commissioner, in the motion that you just made, that they sign an agreement and a release of all claims surrounding payments?
Correct. I did. I mentioned the agreement, but yes, that is, the agreement includes a release.
Payments would not be made until
Each kennel owner.
signs an agreement and a
Correct.
release. Right. Any further discussion? Thank you for sticking with this one. This has been complicated. All in favor?
Aye.
Opposed? Ayes have it.
Thank you.
I'm going to exercise the privilege of the chair for another brief recess. I'll be right back. We won't start before Aaron gets back.
I appreciate it.